Okay, good evening, bonsoir. Je m'appelle Rosalie Juquier, je suis la vice-doyenne à l'enseignement ici à la faculté et je suis ravie de vous souhaiter la bienvenue ce soir à notre conférence John P. Humphrey. Tonight's lecture is special in many ways. First, it is really so good to be back, at least semi in person, and to see some of you physically here in the faculty, with many others I know tuning in on Zoom. Welcome to you all. But secondly, the Humphrey Lecture is taking place during the Bicentennial celebration year. And so this gives me the opportunity not only to celebrate John Humphrey, his memory and his legacy, but also it gives us the opportunity to showcase our wonderful Bicentennial website and for me to take you on a little ride through that website for you to see how we have highlighted John Humphrey as well as the rich and complex history regarding human rights at our faculty and in our wider community. En premier, laissez-moi vous parler de la conférence Humphrey elle-même. La conférence annuelle John Peters Humphrey a été créée en 1988 afin de souligner le 40e anniversaire de la Déclaration universelle des droits de l'homme des Nations unies, dont la première ébauche fut rédigée par John Humphrey. Humphrey est un diplômé de notre faculté, où il a obtenu son diplôme en droit civil en 1929 et un professeur de droit à McGill de 1936 jusqu'à 1946, où il a enseigné le droit romain et le droit international. Nommé doyen en 1945, il n'a toutefois jamais complété ce mandat, puisqu'il a quitté McGill en 1946 pour travailler aux Nations unies. So this lecture centers on the theme of the role of international law and organization and the worldwide protection of human rights. What better way to honor and recognize the leadership of John Humphrey in the elaboration, drafting, and promotion of the United Nations Universal Declaration on Human Rights. Fittingly, the inaugural lecture was delivered by John Humphrey himself, and many other outstanding human rights scholars, activists, and public servants from around the world have delivered subsequent lectures. Tonight, we are delighted to welcome Okafor of Johns Hopkins University School of Advanced International Studies, who will be introduced shortly by my colleague, Professor Frédéric Maigret, who is the co-director together with Professor Nandini Ramanujan of our Center for Human Rights and Legal Pluralism. But before I pass the baton to Professor Maigret, I'm going to take the opportunity of having la parole to show you a few highlights of our Bicentennial website that are particularly relevant to tonight's lecture, but I hope it will whet your appetite for you to play on the website more broadly when you leave here tonight. So our website is entitled Leading in Law Across Time, deux siècles à l'avant-garde du droit. And it is organized by dividing the faculty's timeline into 10 unequal periods from the beginnings of the law faculty in the mid-1800s to the present day. So you can see that John Humphrey fits within the 1939 to 1952 period entitled From Chancellor Day Hall to the World. And I can tell you that he and his story are featured very prominently in, and he is indeed the poster child of this period. But other notable mentions in the same period include the admission of women to the Quebec Bar in 1941, and here's a photo of Annie MacDonald Langstaff, the first woman to graduate law in 1914, but who was only admitted to the bar posthumously in 2006, as well as the naming of the first Jewish judge to the Quebec Superior Court, Harry Batshaw, in 1949. Subsequent periods also highlight other notable achievements in the area of civil liberties and human rights, including the expansion of our professoriate with our pioneering women professors. Here at the top left is Jane Glenn, the first full-time female law professor, The next photo is of Frederick Phillips, BCL 1956, the first Black lawyer admitted to the Quebec Bar. Next is Dean Maxwell Cone, of course, famous for our national program, but featured here for his contribution to the Canadian Charter of Rights and Freedoms. Top right is Irwin Cotler, professor and minister of justice, but also an activist for political prisoners. And of course, at the bottom right is F.R. Scott, featured here for his fight, famous fight for civil liberties and the rule of law in the courts. In later periods, I can have a little taste for how we have highlighted the diversification of our faculty with the hiring of, for example, Professor Adele Blackett and Indigenous scholar Aaron Mills, the very creation of the Center for Human Rights and Legal Pluralism in 2005. And you can see their very beautiful and colorful logo in the middle of the top line of photos. And of course, among the various activities of the center is that it now brings you this lecture every year. But the website also covers things as how members of our faculty reacted to Quebec secularism, Bill 21, seen by many to represent an affront to religious freedom, as well as on the bottom right, the law students' role in a wonderful project on feminism entitled Law Needs Feminism Because. So as you can see, I'm very passionate about this website and I could go on and on, but I've already gone way past my allotted time. So I'm going to leave you with the last slide, which is to tell you how to get on the website. You don't need to copy down that fancy URL. You just need to Google McGill Law Bicentennial website. You'll easily get there, and I hope you'll enjoy the visit. Merci pour votre attention. Et maintenant, j'ai le plaisir de passer la parole à Frédéric.
Maybe I'll stand.
You're taller than me.
Ooh,
I couldn't see the front of you.
Cher Obi, c'est un grand plaisir de t'accueillir. On t'a attendu et on est ravis que tu sois là parmi nous. My role tonight will be very introductory. I'm there to introduce you to our audience and remind everyone of your many accomplishments and what brings you here. So, as Rosalie already helpfully noted, you've just very recently been appointed the John Hopkins University School of Advanced International Studies as the Edward B. Burling Chair in International Law. Before that, you were known to many of us as one of the pillars of Osgoode Hall Law School, where for many years you held the inaugural York Research Chair in International and Transnational Legal Studies. I think a lot of conference people want to keep those short, but I think this is your day. This is the Humphrey, and so I get to give maybe not the full CV, but select highlights. Just I think to give a sense of, in French we would say your rayonnement and the world that you managed to connect through your travel, through your scholarship. So before Osgoode, you held a faculty position at the University of Nigeria. At Carleton University in Ottawa, you served as an SSSRC MacArthur Foundation Visiting Scholar at Harvard Law School's Human Rights Program, a Canada-US Fulbright Scholar at MIT, a visiting professor at the International Institute of Human Rights, or Strasbourg, I should probably l'Institut International des Droits de l'Homme, and then a visiting professor at the St. Augustine International University in Kampala, Uganda, and as a chair of human rights law at the Nigerian Institute of Advanced Studies. Obi, you're known for many things. Some maybe, I'm sure, will be very familiar with your work on refugee law, but and I highlight in particular your very recent book, Refugee Law After 9/11, Sanctuary and Security in Canada and the United States, which I think is a very timely contribution to that debate. Plenty of work also in particular on governance in Africa, international organizations, but also long-term investment in third world approaches to international law, of which I think you're one of the leading articulators. You are a co-editor-in-chief and founding general editor of the Transnational Human Rights Review. And I think you're probably one of the few persons in my mind to have straddled the 12 approaches and human rights, and I benefited hugely from reading a chapter that you wrote for a collection I edited recently around the life and work of Philip Alston, which I strongly recommend. The book will be out soon, and my own personal judgment is this is kind of the best chapter in the book, so I highly recommend it. And I highly recommend it because not only does it straddle 12 approaches and human rights, but also a different kind of aller-retour between scholarship and being, in the world as a practitioner, activist, voice for, but also harsh critic of the Human Rights Project. And so I wasn't surprised, but of all the special rapporteurships that you could have been elected to, it was as UN independent expert on human rights and international solidarity. I think it's a really interesting mandate. It's a cross-cutting mandate that connects the individual and the collective in ways that a lot of human rights mandates don't necessarily. You had already been on the advisory committee to the United Nations Human Rights Council, so you know that Geneva beats quite well, but being an independent expert is a different game altogether. I think people will be really waiting and curious to hear what you have to say. I think partly because we're living such a crisis of international solidarity, and that the special rapporteur, the independent expert mandate seems to be tomber à point nommé, to arrive, just at the right time. So I've spoken enough. Obiora, in the name of the Center for Human Rights and Pluralism, my co-director, Nandini Ramanujan, all center members, everyone present, in the name of faculty, we're delighted to have you. Yes.
Well, let me begin by thanking my dear friend, Professor Andre. So I'm not too muffled for that extremely generous introduction, for which he is known. Also thanking co-director Nandini, all the faculty staff, especially Sharon, who's I don't know if she's still here, who's done a lot of back and forth to make today possible. I'm really grateful for the invitation, the opportunity once again. I think it's one of your doctoral students that reminded me that I was here just before the pandemic. It's fitting to reappear, as the pandemic recedes, in a manner of speaking. Again, so I like coming to McGill and Montreal, one of the great institutions, not just of our time, but as we've seen, for a long time, a great institution. It's also everyone here and virtually here for lending me and us your ear, so to speak. It's a special honor, I feel, to be invited to give the John P. Humphrey lecture, someone whose work I've read a lot, someone whose work I've taught for nearly 30 years, and someone who's so accomplished in my primary subfield in international law, which is international human rights law. So when I got asked, I don't think I wasted half a second to say, yes, I'll do it anytime, under any conditions, COVID or no COVID. And so it's a real honor to honor his memory and his work. Humphrey's work was forward-looking, certainly for his time. So I thought, what better way to honor him than to present what I see as a forward-looking paper. A paper, as Frederick hinted, at least I consider suitable for our time. And so the topic for today is the possibility of a right to tease our imaginations about a possibility for of a right to international solidarity, looking at its suitability as a human right, its provenance, its character, and its orientation. I want to also pay tribute to Dr. Maxwell Obiora, with whom I co-authored the piece on which this is based. Sometime in February 1996, in a lecture down south at Pace University, another great Canadian international lawyer, George Ronalds and John MacDonald, firmly declared that solidarity is a fundamental, unquote, and a fundamentally sound principle, emphasis on principle, of international law. So over time, and you can look at work by people like Rudiger Wolf from Zima and people like that, great European scholars who have made a similar point over time. So this sort of it's crystallized what Ron St. John MacDonald said in 1996 into a kind of aphorism. It's been widely dispersed. Sorry. But there is a difference, as I'll point out, between a principle and right. Okay, I'll get to that. Hence the necessity for the inquiry that I began. There is a proposal as we speak at the UN Human Rights Council. It's been there for a while. There's too much movement to date, but it's there, for the emergence of international solidarity, not just solidarity, but international solidarity as a more widely accepted human rights norm. And this proposal is built, albeit only in part, on the idea or the crystallization of this principle of solidarity as a fundamental one in international law. It has enjoyed its strongest support from what you might call or refer to as countries of the global south. It has enjoyed its least support from countries of the global north in that form as a proposal for a right. So in this paper, what I explore, or what we explore, is to clarify, or attempt to clarify some pertinent questions concerning the candidature, what I call the candidature for, if you like, and taking some creative liberty with the language, human rightness of the proposed right to international solidarity, while recognizing that its status as a principle is beyond reasonable debate. Now, so hence the need to focus, I think, more on this other question of human rightness. Now, I want to, at the outset as well, distinguish that from a related and often conflated question as to its lawness or law quality, whether this can be a legal right. In my mind, that's not the same question. Human rightness does not equate to legal rightness, if you like. There are two separate questions that are related, but I think they need to be held different, separate and apart. It can qualify for human rightness without qualifying for lawness, if you like, and vice versa. Okay, and I rely in part here on some work by Amartya Sen, his famous speaker. I forget the exact title right now. So the presentation, I don't know how long, as Frederick knows, we can talk forever, professors, how long I actually have.
At least 2 hours. No.
That would be great.
About around 40 minutes. So we can have questions.
Excellent,
Yeah.
excellent. I really want questions. So I'll kind of forgive me if I speak through certain things that I should discuss in a more deliberate way, but which due to time I can't really get to. But hopefully in conversation, if there are questions, we can touch on them. So, so what I want to do is offer a short background, a kind of lay of the land discussion of the different conceptions of human rightness historically, including along the global South-North axis, but not exclusively necessarily. And it will not be a comprehensive discussion, but a kind of lay of the land discussion of the broad tendencies, right? In this regard, that's all that we have time for. And then following that discussion, I want to take a related but more specific discussion on the difference, or the different positions that the North and the South seem to have on this particular candidature of the right to international solidarity, if we have time. And then I want to consider in greater detail, in more granular way, if we have time, the historical development, provenance, character, and orientation of the specific kind of international solidarity right that has been proposed at the UN, particularly in the draft UN Declaration on Human Rights and International Solidarity, because that's the document in which that proposed right has been discussed as yet in the greatest possible detail. Okay, it's not the only approach to it, but that's the document where it's been discussed in quite a bit of detail. Now, I want to clear from the very outset as to what the overarching argument of the paper is and is not. It is not so much an argument that international solidarity is somehow immanently a human right, or is already accepted as such by every possible actor, every significant actor in the world. That's not my argument, as much as it is that the proposed right can become more fully accepted. Those are different arguments. I'm not saying that it's immanently a human right. That argument could be made. But that's the argument I'm making in this paper. Somebody possibly could make that argument, but I'm saying that it can become accepted more fully as a human right than it is already. Even the conceptual and historical contingency of the demarcation of the boundaries of what human rights are and what they're not. Keyword there is contingency. My point then is to open up a bit, right? And this would not be a surprise to people like Professor McGray, being expert human rights scholars. Open up a bit the idea that we have this monolithic, stable, immanent idea of what human rights are and not, and that somehow every candidate then must conform. That's what I'm getting at today. So I want to systematically examine that before then considering the specific candidate right that has been articulated. Now, the concept, let me look at the first then, the concept of international human rights, of human rights. I think every discussion has to begin with Bentham of human rights and his idea that human rights were just rhetorical nonsense on stilts. Now we're way beyond Bentham. Very few scholars think that human rights are exactly nonsense on stilts. However, even in the early 2000s, Amartya Sen's work makes a case for why the foundations upon which human rights talk is built is often not as rigorous as it ought to be, right? But I'm not saying Bentham was correct, but there is room there. That's what I'm trying to say. So, but in reality, though, the human rights have climbed onto dizzying heights, right? It sits atop a high moral plateau, as Bakalmutua once put it, right? Excuse me. However, it seems to be a particular set of ideas of what human rights are. And again, I'm not looking at those ideas as just a single idea, but a set of similar ideas. And by this, I mean bigger liberal philosophical ideas that seem to dominate both scholarly and public imaginary of what human rights are. And are not, in fact, people like Cranston went as far as claiming that any candidate, right, that does not fit squarely within what he saw as a monolithic liberal understanding of human rights cannot and ought not ever be accepted as a human right. Now again, I think the discussion has gone beyond Cranston, but we'll have to start from that historical debate. But this begs the question, what are human rights? What then are human rights? How shall we know a human right when we see one? What, in other words, define the human rightness or otherwise of a claim? Like I said, I want to offer a short, run a short overview discussion, and permit me if I sort of breeze through things because of time. And as I noted, this overview is not meant to be comprehensive, but indicative. Now, I already mentioned Cranston, but it's important to repeat. Cranston just stands for a group of scholars. A lot of scholars see human rights as simply a 20th century, 21st century name for what was once described as natural rights. And of course, for many in the room know this goes back to scholars like Locke and people like that. However, today, many scholars, human rights scholars, would likely find Cranston's conception of human rights to be rather too dated and rather too simplistic. And this is despite the support he seems to enjoy in large measure, not completely, but in large measure, from great eminent scholars such as Ross, for instance. The reason I say that many contemporary scholars, even liberals, would see it as rather too simplistic is that when you read eminent scholars like James Griffin or John Tasiulas, for instance, right, they frame the foundations of human rights in more flexible ways, not completely different, but in much more expansive and flexible ways. For example, Griffin's idea is that human rights as pressing moral norms are necessary to respecting and protecting our normative agency or personhood. And what counts as human right is what is essential for a person to maintain their status as normative agents or beings capable of evaluating, choosing, and pursuing a conception of from a good range of options. But Griffin and Tasiulas see human rights as individual moral rights held by identifiable persons, whereby violations of the duties grounded by these rights entail the wronging of the right holder. This is a little more expansive and flexible. Not completely different, but a little more expansive. In neither case is human rightness limited to being allowed by your government to do something of paramount importance. And this is important when we get to something like solidarity, which requires positive duties in many cases, not always, but requires positive duties. Instructively, if you go to scholars like Emergence and so on, they've also departed from this from the kind of tighter, older, traditional liberal, bigger liberal frame, offering differently framed conceptions of human rightness than was traditionally the case. Sen, for example, sees human rights as ethical demands that aim to protect certain freedom. This concept of freedom is not, of course, the traditional concept. To qualify as a human right, the freedom must satisfy some threshold conditions, namely special importance and social influenceability, meaning that others, including society and individuals, can possibly do something about it. These are the two main conditions for say. Unlike some of the moral conceptions of Tassila and Griffin, Sen's definition of human rights encompasses both perfect and imperfect obligations. In other words, there is a broad range of duties for a broad range of agents, right? But different kinds of duties for different kinds of agents depending on their position. So, for example, he gives the example of torture. The police have more perfect obligations, meaning they're more immediate, for instance, not to torture those in their custody. But those who can do something about it that are not immediately situated in that environment also have an imperfect obligation to do what they can. And this is important, again, when you have to imagine solidarity rights, especially across something as broad as the globe, right? This is an important thing to think about. Excuse me. Scholars like Jack, I'm going to breeze through this, Jack Donnelly, Susan Walls, and so on, have made, and Mapao Mutua have made similar points as I'm trying to make about how what we see as human rights is influenced by history, by culture, by our cognitive the character of our cognition, social cognition, and so on. Makabuto has convincingly argued in favor of the ineluctable limits imposed on our cognition and therefore on our conceptions of human rights by various of these particularities that we labor on the political ideas that we're taught, socioeconomic context factors, ethical belief systems, and the like, and realities like we face today with things like COVID-19, for instance. Now, the overarching insight produced by these sort of sets of scholars that have canvassed on the question at hand is that there's not as much immanence to human rightness as is too often assumed or implied, especially, I dare say, in Western human rights thought. I don't want to get into Habermas and all that because I don't have time. But I want to talk about Hassan, who has more directly talked about solidarity, the right to international solidarity, and didn't like it too much. Although he's quite skeptical of, and I've had actually a personal conversation with him about this, he's quite skeptical of what he sees as an increasing expansiveness generally of the human rights frame to accommodate a variety of here to unacknowledged claims. He ultimately agrees that the narrow liberal understanding of what human rights are and are not, and the content of the current corpus of human rights norms can be expanded, albeit within, according to him, certain more narrowly stated limits than the current UN practice is one to. In the end, my own view is that Dembu's deliberative approach is winning out over the more naturalist approach, which looks to human rights as somehow immanent. This is not to say there's no immanence to human rights. It's just to say that deliberation is key to what gets selected, adopted, and legitimized as human rights and what does not. Deliberation is important. And this deliberation, of course, happens within a certain bounded space-time and so on. There is no givenness, right, to what human rights are ultimately and are not. If you look at a brief survey, do a brief survey of the current body, if you like, a more kind of empirical term in my analysis, of international human rights text. It sort of underscores the point that I'm making. And if you look at that over the long duration, right? If you look at the European Convention on Human Rights, on the day in which it was first adopted, it looks almost nothing like what it looks like today, right? Where's the immanence? Where's the tablet from heaven that somebody brought down that is there for all time, right? So what you saw with that convention was that protocol after protocol, economic and social rights were added, so many other minority rights are elaborated in different conventions and so on. And the human rights framework for the Council of Europe began to look more like what the African Charter, for example, looked on the day of its adoption in 1981. I get to where I'm going with this, right? The reason is not because the Africans were somehow more brilliant about conceiving human rights. They just operated adopted the charter in 1981 in a time in which deliberation had evolved. Deliberation had gotten to the point where already you had a binding right to healthy environment in the African Charter in 1981. The first in the world, I must say, which is important because the UN only just adopted that this year in 2021. It was debated for decades, but eventually. So this is my point about deliberation. If you look at the American Convention, the same point applies. Look at the way in which economic and social rights made it into the legal framework of the inter-American system. Even if you look at the African system, look at the way in which the African Commission has introduced indigenous rights jurisprudence, for example, through the right to development and other technologies into the charter. So deliberation for us at least is key. Now, so the point, overall point is that this contingency of the conception of human rightness should form the conceptual baseline for any reasoned discussion of the human rightness of the proposed right to international solidarity, and must frame and shape the discussion that follows on its suitability or otherwise as a human right. Or again, I must emphasize it as sharp a critic of the UN's practice of expanding the corpus of human rights norms, such as Hoshanam acknowledges this point. And so my analysis does not begin from the point of an inflexible definition of human rights that is rooted in the thought of relatively few scholars from only one section of the globe, but rather which are much more open-minded, globally sensitive, and universally relevant understanding of that concept than is sort of the traditional narrow liberal frame that will tend to allow. And so, well did Philip Alston, who was mentioned, who I'm a great fan of, reasoned a long time ago than most of you would care to know, when he argued decades ago now, that the then proposed and still fairly controversial human right to development was not inherently incompatible with international human rights law, because the UN's conception of human rights does not stand exclusively on the foundations of natural rights theory. So he had already said, well, everything that we've been bothering with for the last 15 minutes. Boston said this in the early 80s, right, already. He further adds, and I agree, that the philosophical foundations of international human rights law can be found in a more diverse, pluralistic set of justifications. So applying an unchanging non-changing formal list of substantive requirements as the litmus test for human rightness will tend to be rather realistic, at least on the global level. this is because universally acceptable substantive criteria will tend to be difficult to devise and apply. Now, I again want to note that this is not the same thing, neither Austin nor myself is arguing this, right? This is not the same as arguing that absolutely no guardrails need to be erected or any broad working conception of human rights employed, without arguing that, right? What we're arguing is, given the diversity, not just of the war, but of the conceptions and historical experience across the globe, we need to be sensitive to the need for human rights to be much more embraced, and that tends to be, especially, maybe I'm too steeped in UN debates at the UN when I see certain delegations walk out and so on, of certain discussions. And this goes, all sides, both ways, right? And so, what to do, right? How do we then know? Again, how do we know what human rights are and what they're not? Austin has long offered a plausible suggestion in favor of applying certain procedural safeguards to the UN's process of assessing the human rightsness, that the human right quality otherwise of a candidate, right? And according to him, of course, the General Assembly, as he has convincingly argued, ultimately makes the decision. But before that, the procedural criteria he stated as follows: it is necessary to obtain input from a wide variety of sources, and this input must address as many as possible of certain substantive criteria as well that he lists. I'll return to that later if I have time. And there's need to be several phases of consultation and expert input. Now, this may look like backwards procedural guideposts to deciding what human rights are, but his argument is that this is all that is workable on the global plane. Now, it's not completely absent of substantive criteria, but I'll return to that. Now, so in the light of, we adopt Austin's procedural approach, the light being convinced by his argument. And what I now want to do is to, before applying that test, we're going to apply that test very briefly, but we want to look at a bit more detail about the specific arguments that have been made for and against the emergence as a human right of international solidarity, or the emergence of the right to international solidarity. In the paper itself, we define international solidarity, but because of time, I'm going to leave that to question and answer. You might say you should have started with that, but it's okay. It's a teaser. Imagine what you imagine. We'll return to what it means, the definition. Whatever you think is okay for now. So, what are the objections to the candidature of the proposed right to international solidarity, and what responses might we have to those objections? Those who hold the oppositional view or position against the human rightness of the right to international solidarity tend to do so on three main grounds. The first is the alleged inherent or immanent unsuitability of the international solidarity right as a human right. The second is the claimed excessive vagueness or expansiveness of the proposed right. And the third main objection is the lack of broad international support for that right. Okay, so three. The first, we have kind of dealt with this issue of inherent unsuitability or non-suitability. I've made the argument that it's not inherently unsuitable as a human right because there is no immanence to begin with. Okay, that's kind of put simply, and we can develop this more in conversation. So I will not let that detain us. So I move quickly to the second objection, and that is people like Alston, not Alston, Hannon, Salman, that great scholar. They've argued that it's unrealistic to create a new right without knowing precisely what it means. Okay, so I tried this with my last human rights class last year at Osbit, and I tried a few rights, and I asked them, what does this right precisely mean? It's very difficult. Even rights that you think you know what they mean, right? And so you can see where I'm going with my argument. But let me develop slightly more what their objection is. For example, Hannon is a good example. He charges that rights claims such as the proposed right to international solidarity suffer from a very high degree of generality and ambiguity. So his point is not that there's some ambiguity, which he agrees, law tends to have, rights tend to have, right? But it's a very high degree of generality and ambiguity. This resonates with Alston's old caution that we should only accept new human rights that have a degree of specificity or concreteness to enable them to be operationalizable, okay? Which is all good. There's of course a sense in which the proposed right to solidarity embraces a broad concept, right? Nobody can deny that. I have pointed that out myself in 2 separate papers, so I can't stand here and deny that. Professor Jaya Ramji-Nogales has also done so in a recent symposium, saying that solidarity itself can mean different things to different people depending on their mindsets and goals, right? But to counter this tendency somewhat, I began to limit myself. This is another hat I'm wearing now as an UN independent expert on international solidarity. When I use solidarity, I can use progressive solidarity and so on, right? Understanding that there is some malleability and vagueness to the term. But like I've said, it should also be noted that as Scandinavian American realism, others and critical legal studies, very few human rights texts escaping determinism, right? It's very difficult to find those. But that in itself does not sort of make my point. So while it is admitted that the right to international solidarity seems to be couched rather more generally than, say, the right to freedom of expression, or the right to food, or the right to assembly, we must also note, though, that the body of already well-accepted human rights in the International Bill of Rights, the ICCPR, the ICSCR, the Economic and Social Rights Covenant, and the Civil and Political Rights Covenant, and the Universal Declaration, do contain different types of rights, many of them that are couched as general, right? Already, they do contain rights that are as couched as general already, and that the bandwidth within which those rights are couched differs, right? They're not all within the same bandwidth, if you like. For example, the right to fair trial is one of the most vague rights, if not for a systematic sort of attempt to then detail what it might mean, right? When you say fair trial on its own, it contains maybe 7 or 8, 9 different other concepts, right? It's not as precise as you might imagine. It's not as precise as the right to be free to leave one's country, for instance, hardly. And think of the right to self-determination in Article 1 of each of the 2 covenants, the common Article 1, right? Self-determination is notoriously indeterminate concept, and I'm speaking in Quebec, so this should resonate. And how specific really is the right to be free from torture? If you look at the book that Frederick kindly flagged, I go through both Canadian law and US law, the various devices which these two states use to take advantage of the vagueness of that right. What is mental torture? At what point is the pain torture or not, right? It's extremely, if you actually delve into the concrete application of that right. Now, I'm not saying that the right to solidarity is exactly the same or occupies the same bandwidth as the right to be free from torture, but I'm just saying that a lot of these things that we assume that are specific are not as specific. And how about the right to social security or the right to democracy? I don't know where it's stated, but a lot of people believe there's a right to democracy, including myself, at least on the moral level. But that would be a very vague right. What does it mean? Does it include an unelected Senate, for instance? I don't know. Is Canada undemocratic? I don't know. Is the US democratic because it has an elected Senate and Canada does not? Right? And I'm just giving you examples. Okay. In any case, though, the point I think I've already made this point is that the right to solidarity, to national solidarity, can be further specified, and this is already begun with the current draft of the UN declaration on the right to international solidarity. I think it needs more work, and I'm working on that personally, my capacity, but I think it can be further specified to make it more specific. So I don't think that it fails purely on this score. I was going to, and I think I should, given the times that we live, just to give quickly two instances of specifics or how the right to international, proposed right to international solidarity can be further specified. For example, if we talk about the right to international solidarity in the health context, and we talk about access to COVID-19 vaccines, or we talk about a right, a duty, for instance, to wear your mask so that you don't infect. Masks protect the other person, mostly, so that you don't infect the next person with COVID-19. That's a very specific form of a solidarity right, including in the international context, because the spread and circulation of the virus in one place, for example, Delta variant in one place, could have very, very immediate consequences for our health here, right? We've seen that demonstrated scientifically and empirically, right? So I just wanted to illustrate with that. Another way in which it has been actually applied in France with the Cédric Leroux case is a French court actually based his decision on Mr. Leroux's right to show solidarity to irregular migrants to free him of a criminal charge of smuggling, human smuggling, and say he cannot be guilty of human smuggling, a criminal charge, if he has a duty under the French Constitution to show solidarity, right, to people on his farm. Do I have any time left? Okay.
5, 10 minutes.
About
5, 10 minutes, maybe.
all right. Okay. The last objection is that there is no broad global support. I think that one can quickly respond to this by saying actually it's supported by the vast majority of states who represent 90% of the world's population. So I don't think also that that's a viable objection to its emergence. Now, very quickly, in the time that I have, if we were to apply Philip Alston's procedural test, right, for the emergence of a new human right, if you look at the first one, were inputs obtained from a wide variety of sources. The right was proposed after extensive consultations, where the issues that he mentions addressed. They were addressed, just so that you get a sense of the substantive criteria that also offers the issue that were addressed was whether an important social value was reflected. I think you would agree with me that solidarity, for example, in the COVID-19 context, is an important social value. For irregular migrants, that's an important social value, and so on. Is access to vaccines and so on. This is very important. Is it relevant to the entire globe? It is relevant to the entire globe, even in its diversity. Is it eligible for recognition as an interpretation of the UN Charter and other international obligations? It is, because it gives effect to the principle of solidarity, which everyone agrees, almost everyone agrees, is recognized under the UN Charter. And is it consistent with the existing body? I spent most of my presentation arguing a body of international human rights norms that it is not inconsistent with the existing body of international human rights norms. Was there expert input? There was expert input. And has the General Assembly voted? Not yet, but it could vote in its favor. I have not had time to discuss the details much of the sort of the particular form of that right that is contained in the UN draft declaration, but I just want to say that the declaration specifies the duty bearers, it specifies the right holders very clearly. It's not perfect, it's still being worked on. It also specifies the content of the right. I also want to state that the African Charter, and I dare say again, leads the way, it already concerns a duty to the international community to show solidarity in Article 27. Same for Article 29 of the African Charter. I also want to refer us to Articles 2 and 20, Articles 28 of the UDH, Article 2 of the International Covenant on Economic, Social, and Cultural Rights. I don't even want to get into the refugee area where it is much more developed for reasons of time. And then lastly, and this will be the last thing I will say, Professor Gray, some who argue strongly that the proposed right is unlikely to be ever adopted, may be reminded that as we speak, a binding international treaty on the right to development is currently being negotiated in Geneva under the auspices of the Human Rights Council's Working Group on the Right to Development. This is something that would have shocked skeptics in the 1970s. If you had told them in 2021, that's what a binding treaty would be undergoing development as we speak. Certainly would have shocked the Senegalese jurists, Dudu Thiam and George Kebambaye, who first proposed this idea and introduced it in the African Charter. And so, while it's clearly not yet uhuru, as Africans say, for freedom, success, for the proposed right of peoples and individuals to international solidarity, it's certainly too soon to sing its non-dimitives either. Okay, thank you so much.
Thank you very much.
So Obi, that's wonderful. Obviously, lots to talk about and discuss. I think we'll open the floor for discussion. We have people who are online and may wish to participate as well and ask questions. I'm tempted to maybe get the conversation started. So I think this is really intriguing, and it's almost as if, in a sense, the sequence have been a bit reversed. I mean, you're the independent expert on international solidarity, right? So how could you not militate for the existence of a right, right? I think it's one thing to appreciate the importance of solidarity as a value, with maybe an occasionally structuring principle in the international order. I think there may be conservative, sort of reservations about the abstractness, nonsense upon stilts. It's what do we need another right for? But they could also be sort of, progressive critical agendas that are a bit wary of sort of a kind of unholy mixing of the, the register of rights on the one hand and of sort of, third world values of, sort of global values of solidarity, right? So one of the questions is what's really gained in the exercise, right? And so if you try to concretize right to solidarity, I fully take on the point that no right is a priori, fully determinate, etc. But there's still going to be questions about, well, so, if there is a right to solidarity, who has it and against who, and in what kind of circumstances would it help, right? So pragmatically speaking, right? I mean, are we more likely to have solidarity simply because we have a right to solidarity? And also, is solidarity, doesn't it kind of kill the fun of solidarity, but it's now a sort of entitlement, right? Now, I was trying to think, so is there a human right to love, right? Well, of course, I mean, you have a right to not be denied love, but you can't really, can you force people to love you? Not really, right? So, and I guess maybe solidarity is a bit different because it's a social value as opposed to sort of interpersonal, emotion, etc. But there's still something about, doesn't kind of the liberal discourse of entitlement sort of weigh down and sort of render mechanical some of our political passions, right? That would be my question.
As usual, an excellent one and very relevant, which we allude to some extent. I couldn't get to everything. Meaning, what is the value added decided by doctoral students? What you would be like the so what question, right? Like what's the value added here, right? If we can get it through love, why not? Who doesn't like love, right? Well, I will not necessarily to you, but I'll remind the audience that law is congealed politics, right? And limits as such the field of argumentation. So do legally recognized rights, right? In the UN sense, the human rights, if it becomes accepted as human rights, will become sort of soft law distinction. It begins to make arguments against certain values, extremely important values, like, for example, not being wiped out by COVID-19, not having more variants, mutants upon mutants circulate because 80% of the world remains unvaccinated, because certain states would not allow generics to be mass produced by India and South Africa. Those arguments would be more difficult, which is why, for example, HIV/AIDS, we went to Doha, right? We went to law. This is not human rights, but we went to law, right? In order to essentially force pharmaceuticals to make HIV/AIDS medication available, right? So it sort of shrinks the space of the ballpark, but there will still be a ballpark, and that's my point about indeterminacy, sort of goes to that. But the field of the ballpark shrinks, right? In a way that it becomes extremely beneficial and significant almost immediately, like HIV AIDS and Doha Agreement on TRIPS and public health, right? That's why activists campaigned for years for Doha, right? Not because pharmaceuticals were not given some free AIDS medication here and then, and things like that, but it kind of limited their maneuvering a bit more, whilst of course maneuvering remained possible. I think that the solidarity right has a capacity to do that, and indeed, as a principle, has showed promise to do it. For example, when the EU issued this, for want of a better term, the export control, vaccine export control regulations, if you read that regulation carefully, it mentions the principle of solidarity and exempts about 31 countries on the basis of the principle of solidarity, right? Now, a more powerful argument would have been the right of people in those countries to solidarity in the COVID-19 context, getting that drug, right? So it's shown that kind of promise in that context. Another area is, I have a paper in the last 2020 American Society of International Law proceedings, conference proceedings, where I discussed the various places, including the Cedric Hérault case in France, where this principle basically stopped people who express solidarity to irregular migrants from being jailed, right? And things like that. So I do believe that it does have a potential for value added, and that it limits the maneuvering that you often see from various actors, such as the states and so on, right? And if you flip the sort of not flip it, but if you move to a slightly different, shall we say, but connected sphere of argumentation, and you talk about R2P, responsibility to protect, what you see is that the actors flip. Those who are against the right to solidarity then insist on their duty to intervene, right? Right? So my point is, one of the things I developed here is, what is the theory behind that? So if we say the theory behind that on the best R2P is global community that is dense enough, right, to require us to have this responsibility to people that are 7,000 miles away. Why is it in the COVID-19 context that that argument does not apply? This doesn't necessarily speak to the rightness or otherwise of it, but it speaks to the lawness or obligatoriness of it, right? So what you find is that there's a politicization of what then is adopted, right? So when it comes to RP, the global South states who loves it, that will say, no, we don't want that kind of solidarity. We don't want you intervening. And you get what I'm trying to say. Yeah. So it's not said the immanence for me or not of its suitability. There is a politics that is a power play that's going on, that is shaping power sort of constitutes in this sense. That's partly what I'm getting at. Yeah.
Fantastic stuff, Tanya.
Yeah, thank you so much for this wonderful, interesting topic. And I just wanted a clarification question, which is on the question of the kind of right that it is. So I can imagine when you're talking about the right of the farmer in France who wanted to give aid to the refugees, to the migrants, that it's invoking a right to show solidarity. But sometimes it sounds like it's the right to have solidarity shown. So then the question is the obligations. How would you articulate the kinds of duties and obligations? Because I always, when I'm thinking about solidarity, I think of it more as an obligation, as a duty, rather than a right in and of itself, except in the French case. So
can you say that last bit of it?
Yeah, sorry,
Matt,
yeah. So I often think of solidarity as an obligation. Like you have the duty to solidarity as opposed to the right. And so I just, how do you clarify or how do you untangle the two when you're thinking about it in terms of the rights? And I know in like the African Charter, for example, there's a much more of implying individual obligations. So like children's rights to culture, and you know, in the language it says they also have an obligation to their parents and to their society.
Yeah.
But it's not as, you know, there was a lot of debate on the Convention of the Rights of the Child from countries that said we can't have an obligation placed on children in the convention. So can you say something about that, like the duties and the obligations that are implied in the right to solidarity?
Yeah, so I'm slightly Orwellian in a sense when I think of rights and duties, right? So two sides of the same coin, and dependent context will shape what formulation is meaningful, right? So for Mr. Heroux, for instance, Monsieur Heroux, for instance, in France, being taken to court, and it's just not just Heroux, you can count probably 20 people who've been charged, for example, in Italy, for example, human rights activists rescuing persons in distress in the Mediterranean who've been charged to court and who's gotten off, not necessarily based on invocation of this principle as well, but my point is that this would be relevant to them. So for people like that, it will be their duty to show solidarity to the irregular migrants, right, who are in distress or who require solidarity on sea or land. To persons who lack vaccines, for instance, or access to vaccines, it might be a right. What might be meaningful might be a right to solidarity, to expect generic vaccines to be provided, right? Or the formula for generic vaccines to be provided so that they survive on the basis of solidarity. And it's not the arrow of solidarity in this case doesn't point in one direction, just in this COVID case, right? Because if they don't have vaccines, we're going to keep getting variants that will come back and haunt all the people who have ordered the vaccines and the formulas, right? So the arrow would point. If I don't wear my mask in a certain proximity, I have a duty that I'm breaching to show solidarity to you, and vice versa. So I think it depends on the context. So that's the way I kind of think about it. Yeah.
Thank you. I find the idea of a right to solidarity really, at the very least, a great thought experiment on human rights, because it seems to approach it from a really different angle. Whether it works as an actual right seems to be a different question, and if you could separate those two conversations. In many ways, for me, it sends us back to Karel Vazak's old idea of generations, and solidarity and fraternity have a lot in common. I'm not sure whether they're the same thing, but it also sends us back to the French Revolution itself, the inspiration for Vazak's classification, and to ask the question, why was it necessary to have fraternity in addition to equality and liberty? And I think that the answer in part reflects the idea that this was a declaration not only on the rights of man, but also of the citizen. And I think the idea of solidarity speaks to a certain notion of global citizenship. What do we owe each other in a very kind of general way? And that seems to be, to me, where there's a point of tension with the human rights discourse otherwise, which is much more targeted, specific, jurisdictionally based, and so on. And there's a bit of an unease there as to how these things work together. It goes a little bit to Fred's point about, do we want to make solidarity an obligation? And isn't that going to ruin the idea of solidarity reminds me a little bit of Emmanuel Levinas's discussion about hospitality and how, you owe hospitality only to strangers. Because if it's a relative, it's not really hospitality. It's another relationship that you have. Hospitality captures something about the generosity to the stranger. And solidarity seems to be a little bit like that. And I worry that you're going to kind of ruin the concept by turning it into a right. Maybe our last point is that it might also be sort of an answer to the critique of rights about, well, rights, they particularize, individualize, fragment issues, and then solidarity can be the sugar to make it less bitter and to reestablish the balance and to say, well, it could be a principle that is not so much an independent right as a right that is in conjunction with other rights, so that the right to education has a solidarity aspect, so that it's not purely top down in one jurisdiction, but there are solidarity dimensions above and beyond what a duty holder owes to somebody else. Because to go back to Levinas, if you owe it anyway, you don't need this extra little bit that speaks to human generosity that solidarity seems to speak to, which reflects a broader, I think, idea of citizenship.
Excellent, excellent arguments. I mean, if you look at both sort of what commends it, what doesn't commend it. Though I completely understand the point, which is why I'm not yet making an argument that necessarily should be, either we could be, given the trajectory of other rights that are accepted. And what is being negotiated in Geneva, as to see, you would call, for example, the right to development. Actually, if you look at the original conceptual framework, came from solidarity, right? So, for example, that's what I'm getting at, and that these arguments, specific arguments by specific scholars, not necessarily the arguments made. I've not treated the state arguments here, really. It's arguments of scholars. I wanted to look at whether these arguments are a real obstacle to them becoming accepted or not, to what extent they're an obstacle. So that was kind of the main project. It's interesting you raised the point, a very interesting point, which I've also thought a lot about, which is the connection between fraternité in the French context and solidarity. It's interesting. The Heroux case is quite interesting because actually what happened in the French Constitutional Court actually derives solidarity from fraternity. Right? So there's no sort of separate solidarity clause, shall we say. That's what they do in order to then set him free, right? Which is interesting. So they didn't necessarily say they're exactly the same thing. They just said that there is an element of solidarity within fraternity. In terms of the notion of global citizenship, the way at least I've thought about it is that it seems to me that there's a kind of performance that states undertake around the North-South axis. Both the global North and global South states often talk about global citizenship in a dense way, but only for certain purposes, right? So when you look at it closely, it seems that there's widespread agreement that we do have dense enough global citizenship, but the difference is what is the issue at hand, if you like, right? So if we sort of have everyone agreeing at some level and for some purpose that this is dense enough, then why can't we have obligations to each other across the globe? You get my point? That's kind of the move I was making there. Why not, right? So, in terms of the unease that with yourself and Frederick, as mentioned, of course, I recognize that unease, but I actually feel, I mean, Frederick makes the point that I do wear two hats, so how can I speak against it? But I try not to bring that into this as much as one possibly can, right? I think also perhaps that one of the reasons I was appointed, because you want to have to apply, was that I made a good case for solidarity. So I think there's a sense in which I came to it already with my own, things. But I do understand, and the bureaucracy is often getting mad at us for mixing up our two. They don't want us to speak in an academic capacity at all, which we have rejected. But because of this kind of thing, are you speaking as a professor? Are you speaking as but in terms of making it an obligation, really this beautiful thing, which is hospitality or generosity, shall we say, that we show to each other. The concern from kind of my perspective, actually, that we don't show hospitality and generosity, right? So when I look at the Mediterranean, all I see drowning Africa, right? I know it's a particular perspective. Others see Europe beautiful. Actually, I've told this in UNHCR office, which is very interesting in Norway. So it's a different perspective, right? As I often tell my students, there is no free movement of persons. 90% of the world can't go anywhere. For instance, I don't see hospitality, I don't see. So I think that whatever does some work toward those ends, which I think really, because I'm a globalist at the end of the day, which I think are important if we're to have plausible global community and plausible arguments actually on even in border rights, right? Like, if you make the argument that you have a responsibility, for example, to intervene, let's say, Ethiopia, which is a current, based on this density of community, say, between the US and Ethiopia, the issue sanctions and all that. And you turn around and say, well, not quite when it comes to COVID-19 vaccines. It actually undermines the human rights argument and the argument about that density. That's kind of what I'm getting at. That's where but thanks so much for the question. And the comment.
I'll take two final questions. We have a few questions from on Zoom, but I think it'll be too much. So sir, first.
Yeah, I was just reflecting as you started the presentation. I think you started first with something that struck me, the fact that in the course of deliberations at the UN, the South would tend to support solidarity and the North would tend to oppose it. And I find that very striking because in the climate finance and climate change domain, we see a converse of that scenario. The global North has always emphasized that climate finance should be sort of a solidarity payment, what you call noblesse oblige. But the South would insist that climate finance is an obligation as a result of the historical responsibility of the global North in causing the ecological crisis and perpetuating, accelerating climate change. My concern with the concept of solidarity within the climate finance domain, I'm not so much a human rights student, is that it may work to undermine decades of argument of many developing countries who have insisted that climate finance or climate change support for developing countries is not a solidarity payment, it's not a gratuitous rendering, it's not a friendly extension of assistance to this starving or helpless flood-ridden communities in the other part of the globe, that it's actually an obligatory payment. You could say in blunt terms that the concept of solidarity in the climate finance domain may undermine the conception of climate finance as a human right, as some would like to put it. So I just want to get your thoughts on that.
Yeah. I don't know, I'm not an expert, God knows, so I'm climate. So I shaking my head. We work together on the UN report on climate and solidarity. I'm not an expert on climate. I do, read about it, not like that ad where, some woman tries to treat someone and she's not actually a doctor, but I'll still try to say something about it. I may be wrong, but my sense is that the objection is not to solidarity itself in that context, even in that context. The extent when we walk that the objection is to solidarity as charity. Are you getting, there's a distinction there. The objection is if solidarity is charity. That's the main debate, for example, the right to development along the global north-south axis as well, right? If it's charity, we don't want charity. We think it should be right? So I think that's my own sense. I may be wrong, and that's why solidarity sort of to them has this connotes in a negative way in that particular context, because even today, how much the entire African continent, how much pollution they produce, they don't. So they don't see any fairness in them bearing as much responsibility for writing, the situation they didn't mostly produce. I think that's what they're yeah. So
I'm thinking about many of the last questions that were just asked. So about the north-south dynamics, about solidarity being a dimension of other rights, and about what's at stake. And I'm wondering if we might understand the right in terms of guaranteeing the conditions necessary to realize other human rights. So it's a different type of human rights that gives effect to other human rights. And why I raise the north-south aspect of this is because, of course, solidarity was a strong discourse, an ethic, a practice, a value of third world states and lawyers during the decolonization era. So when you gave us the genealogy of solidarity, you began with Ron say, Donald, my understanding is that he was commenting on third world proponents of solidarity in his time, which was primarily, solidarity in terms of redistribution, global redistribution, and I think he characterized it as more of a cooperation principle. So I was wondering if you could kind of walk us through a little bit the history of solidarity in the sense of, what are those north-south dynamics? Is it about shared responsibility, redistribution, cooperation, to be able to affect other rights that peoples of the third world and states of the third world were unable to do in the context of decolonization? And in that sense, is the right to solidarity also part of the unfinished business of decolonization?
very, very interesting questions there. Yes, I think as I just said in response to the last question, I think that there's a sense in which there were a few, not most of it, but there were a few loosely stated demands that newly decolonized states in the 60s and 70s, they were rooted in solidarity, right? So one was, for example, development, and so on, it kind of, in a sense, also come up with differentiated responsibilities across several areas. Log C, you can see elements of that, application, and so on, right? And so Solidarity sort of have that, if you like, more general provenance as well. But I think that perhaps I should be clear to limit my narration of the, I didn't get too much into the details today of the provenance to, you know, if you like, the human rights trajectory, right? That's what I was kind of focusing on mostly. And if I provided more details about the draft paper, I would have, you know, referred to how, you know, in the deformed subcommission, that idea was then in the 80s, taken from 60s, 70s, and you know, and then studied. The paper was produced by Louis Alves, which led to the appointment of the first special rapporteur. Subsequently, many years later, the government risky, Indonesia, and who mostly studied it conceptually, relating it to development and many of these areas, which by that time as well had also seeped deeply into, including the environment and in a different sense into UN Human Rights Council's work, activities. And later, Virginia Dandano of the Philippines was charged with producing a draft declaration. So that's what she was my immediate predecessor, spent most of her time doing, and it is based on that notion, that particular type of solidarity right, that this paper kind of tried to study and see, is this in that form that was produced, is it capable of gaining global acceptance or not? Arguments against its suitability, as solid as they might at first glance seem, and so on. That's what I was kind of looking at. So my sort of it was biased toward the human rights tragedy. And I forget the very last question. Is it sort of the tail end of decolonization? Is that what you? Yeah.
Well, I wonder, so in terms of framing the right itself, you know, is it really about guaranteeing the conditions necessary to effect other rights, health, development, whatever it may be, that cannot be affected where there is incapacity or power disparities to be able to do so? And to that end, you know, I think thinking about this, grounding it in the context of decolonization, does that mean it still has relevance today in terms of the unfinished business of decolonization? Because it's about laying the conditions necessary to realize a host of other rights that are challenging to
yes, if we look at colonization in a kind of in a broader frame to include the what at least a lot of the newly decolonizers thought was needed to have a kind of new set of global relations in terms of the conditions for those peoples. Yes, if we look at it in that sense, yes, I think we think that so absolutely solidarity is extremely important, except in the area, I would say, of intervention. if I'm to speak empirically, I don't think they're as enthusiastic about it. They are to side. I mean, they've accepted some modified version of the original idea, but not as in as robust a way as the original was stated. They're not as enthusiastic about that. So, well, other than that, yeah, I agree. Yeah.
Lee, thanks so much for this. I don't know if John Humphrey could have imagined as he was drafting, you know, an early draft of the Universal Declaration that there would be an independent expert on the rights of solidarity, you know, sometime in the future. But I'm sure he'd have been fascinated to hear your thoughts as we were. I can testify from where I'm standing that there really is a paper, and Obi was sort of turning the pages, skipping 10 pages at a time. So we know there are many layers to that argument. Thanks for coming with your two hats, the scholar and the UN advocate, and I think we're all in solidarity with your quest. Thank you again.
Thank you.